I have been told that on several different workshops that I go to, several different events, that only about 5% of the cases that are filed proceed to trial. The other 90 to 95 are cases that are resolved through a settlement, either during mediation, prior to trial on the courthouse footsteps, or through settlement negotiations. Hello, and thank you for joining me today. So I thought I would talk today about mediation. So when you're in a lawsuit, the judge at some point may order you to go to mediation, especially since we have a new case that was decided in January through an appellate court that says a probate judge can order parties for a trust dispute to mediation. But mediation tends to confuse people. Mediation is just really another term for the party sitting down with a third party who has a non-vested interest in the case to see if you can work out some type of an agreement. The person you're going to sit down is a third-party neutral mediator. A lot of times this is a retired judge. Here in Santa Clara County, we have several of the former judges who used to sit on the Santa Clara County probate bench and adjudicate matters. We can hire them as mediators. And the mediator goes back and forth between the parties and tries to help the parties resolve it. So if a case were to go to trial, a lot of times it's one side take all. And what I mean by that is most of the time with a trust dispute or a probate dispute, and sometimes even in civil litigation, there's not a halfway. There's not, you're going to win 50% of the case, this other side's going to win the other 50%. If it is a trust dispute, either that trust is valid or invalid. Determining when the judge makes their determination will determine who the beneficiaries are. It's not going to be, well, we're going to add, this side is going to be 50% of the trust beneficiaries, and this other side, we're going to allow another 50%. It's going to be, is this trust amendment valid? If it is, these are the beneficiaries. If it isn't, these are the beneficiaries. And the whole case is decided by a guy or a woman in a black robe, and you never know what they're deciding. That is something called risk to litigation. In mediation, it is voluntary. There is nothing forced about mediation. The third-party neutral, the mediator, cannot force a side to settle. All the settlements are entered voluntarily, and it either ends with an agreement or it doesn't. If it doesn't end with an agreement, the parties are still on track. Next time they go to the court, the judge will say, did the case settle in mediation? The parties say no, and the court brings the case to the next step. And generally, it's setting the trial date. If the parties can agree, then a settlement agreement is generally drawn up at mediation, and everybody signs off on it. And that way you end mediation with a settlement agreement. One of the advantages of negotiating in a mediation is the parties are contouring what relief. And what I mean by that is you can get things out of mediation that the court normally would not award. We had a mediation many, many, many years ago, and it was important to one of the party that they have a party in their honor put on by the other side. And this was a family dispute. Both sides were agreeable to this. Now, a judge would have never ordered this, but for this particular case, it was very important to the aunt that her contribution to the family was recognized. And in the culture that they were from, you did this at a party. So all the parties agreed that a party on this date would be held in honor of the aunt. Like I said, a judge would never award that. The judge would be looking at, is it X or is it Y? The parties can fashion their own relief in a way that they want to. This was something that was very important to the aunt. She wasn't necessarily worried about some of the other damages. She was willing to let other things go. But for her, this was really the sticking point. So we were able to reach a settlement in a way that was acceptable to everybody. So why should everybody in a lawsuit attend mediation? And normally attorneys advise our clients to go to mediation. And a lot of times there's resistance to that. Oh no, no deal can be reached. This person's unreasonable. And there is always a chance that one of the parties can walk away from the mediation with a great settlement that ends the case. There's also a chance that one of the parties will just walk out on mediation. That can always happen. And I have been in mediation where the other side acted like a 3-year-old and they picked up their toys and they went home. And it happens. I've also seen in that same case where one of the parties picked up his toys and went on his way and rejected what I thought was a very good settlement offer. He ended up losing the case, not getting anything. So there is a risk, and litigants, they invest a lot of time and money and emotional issues in a lawsuit. And once again, if a case goes to trial, especially with probate and trust litigation, there is a one-party wins all. And even the strongest and best cases can always carry a certain amount of risk. You can talk to any litigation attorney and they will tell you they have seen cases they thought was a slam dunk and they end up losing. There's also other attorneys, or perhaps the same attorneys, that will tell you, I thought my client, we were losing, there was no way they were going to win, and all of a sudden the judge found in our favor. Talk to any litigator and they're going to tell you both sides of that. One way to alleviate the time, the money, and emotional stress that a suit causes is enter into mediation, and you can get a settlement where probably neither party's thrilled with it, but you will have an opportunity to craft your own relief. And during the mediation, generally the mediator will tell you what his or her take is on the case. He will talk about what the strengths and what are the weaknesses. They'll discuss the pros and the cons of the case with each party in their own separate rooms, so the litigants can get a more realistic view of whether they will prevail from an outsider's perspective. And like, once again, if your mediator is a former judge who adjudicated these matters, it'll give you a lot of insight. And even if the case doesn't settle, mediation can be beneficial as the parties learn about the strengths and weaknesses of their case so they can mitigate those as they go to trial. I have been told that on several different workshops that I go to, several different events, that only about 5% of the cases that are filed proceed to trial. The other 90 to 95 are cases that are resolved through a settlement, either during mediation, prior to trial, on the courthouse footsteps, or through settlement negotiations. Generally, a judge is reluctant to set a trial date until the parties have at least met and conferred to see if the case will settle. And a lot of times that means going to mediation. From the recent January case, the judge can even order the parties to go to mediation. So mediation is not only useful for resolving the case, but it can also increase the likelihood of getting an earlier trial date. So there are a lot of benefits outside of the case settling that can occur in mediation. So I hope that helps you with mediation. Generally, if you're in a lawsuit, and I don't care if it's a civil lawsuit, I don't care if it is a family lawsuit or a trust and estate lawsuit, you're going to hear something about mediation. It is not something to be scared of. It's not something to be, oh, well, I just don't want to do it, because there's some great benefits from it. For family law cases, I can tell you from sitting in Santa Clara County Family Court, even though I do not practice family law, I do know enough about the process that they have mandatory mediation, especially if both parties are unrepresented. In Santa Clara County, they have a free service that is put on by the county, and it is a Santa Clara County pro bono mediation program, where if you have a case that is in Santa Clara County, the county offers a special program that you will be able to have your case mediated, and they do not charge for that. On the other end of the spectrum, for costs of mediation, there is organizations such as JAMS. And those are probably the most expensive I've seen for mediation. Once again, they're generally retired judges. Then there's mediators that are retired attorneys or attorneys that have put mediation to their practice, that maybe they have litigated these issues. They have significant experience in those. And now they're no longer litigators, they mediate. So there's a variety of mediators that are available. Each county generally has a list of mediators or third-party neutrals, but you can always contact an organization like JAMS, ADR or ADR services who have retired judges to find out what their fee schedules are, or in Santa Clara County and some other surrounding counties that I know of, we also have the free mediation service. And all of those can be very valuable in resolving a case. So I hope that answers some questions about mediation. We are here on our Steburg Law Firm Facebook page every Monday, Wednesday, and Friday at 4:30, sharing information about the law, about trust and estate litigation, as well as tax resolution, tax planning, and tax litigation. So I hope you have a wonderful day. If you found this useful, or if you believe that somebody you know will find this useful, feel free to share this out. Share this with them. Because we try to give you, bring value, help you understand a little bit about the court process, a little bit about the terminology. So I hope you found this useful, and I hope you have a great day.